I will start with a brief overview of the procedural background of this evaluation. On 8 July of this year, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On 15 July 2022, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on 5 July 2022. The Commission sent you 3 rounds of questions on August 1, September 14 and October 12. Your responses were submitted in August 5 in relation to the first round of questions, and the responses to the second round of questions were submitted on 17 September, and those relating to the third round of questions on 15 October 2022. You were asked a total number of 27 questions, including 65 subparts, and 24 of the questions included a request for further documentation. You provided answers to all questions and all subparts of questions, and you provided documentation in relation to 15 of requests for such documentation. On 27th of October, you submitted a request to the Commission to include some additional information received from abroad in relation to some questions put to you during the third round of questions. The Commission has accepted this request and will include these materials in its analysis of the questions put to you. As it has, however, not been able to study the materials submitted, the Commission may get back to you after the hearing with further written questions in relation to these materials if required. Please be advised that under Article 3, Paragraph 4 of the Evaluation Rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless the candidate provides sufficient justification for not providing the information as requested. Members of the Commission will now start with asking you questions. Vitaly Miron will start with asking questions, followed by Victoria Hanley. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Mr. Vitaly Miron, I'll now invite you to start the questions.
Thank you, Chairperson. I would also like to greet you. I will start by making a factual presentation with regards to a matter, and as previously said, hopefully the questions will be such as to allow you to answer briefly, succinctly to the questions that will be asked. Now the context. According to your declaration of assets and personal interests submitted for 2020 and 2021, you declared that you are domiciled, having your residency visa in a building located in the city of Hânchești, which belongs to you. In addition, you indicated that you have the right of habitation in 2 other buildings, a house in Hânchești belonging to your son, an apartment in the city of Chisinau belonging to your mother. When the Commission asked you to explain why the right of habitation was not included in the first declaration that you submitted on the 29th of March 2021 for the year 2020, you explained that you did not indicate that right of habitation held in relation to the fact that the apartment located in Chisinau, because you were not sure that you had the obligation to declare that right, considering the provisions of the Law 133 of 2016. Also, you explained that you did not calculate the number of days that you have actually lived in that property with your mother. In order to exclude any doubt whatsoever, considering the compliance with the deadline set by the Law 133 of 2016, you submitted a corrected declaration of assets and personal interests for 2020, where you indicated this right of habitation in relation to the given apartment. In the next round of questions, the Commission asked you whether you had the right of habitation in that apartment for the period 2018-2019, and if so, you were asked to explain why you did not declare it in your declarations for 2018-2019. To this question, your explanation was that in 2018-2019, in that period, you did not live in that apartment for a longer period than the one indicated in the Law 133 of 2016 in order to declare this right, which is why you did not even reflect in the declaration of assets and personal interests information about this apartment. You also explained that occasionally during the year you visited your mother, living in that apartment, to give her some support and the care that she needed. The Commission asked you to explain what provisions you referred to, what provisions you relied on when you indicated that the term of habitation provided for in the Law 133/2016 was not in line with the declaration that you made previously. In your answer, you explained that the obligation to declare the right of habitation results out of Article 4, Paragraph 1 of the Law 133/2016. Also, you stated that you did not have the right of habitation in that apartment for the years 2018-2019 because in that period of time you were visiting your mother occasionally during the cold time of the year when she used to live in that property. You also do not have a real right of possession and the use of this apartment. For these reasons, referring to Law 133, you did not declare the right of habitation in this property. Now, as for the questions, please confirm that in your declarations of assets and personal interests submitted for 2020 and 2021, you declare that you had your residency visa in a building located in the city of Hâncești, which belongs to you. Thank you. I certainly confirm that I have the right, that I have my permit there in the property that belongs to me, that I'm the owner of, in Hâncești municipality, 8 Chisinau Street. The next question. Please confirm that in your declaration for 2020 and 2021, you declared the habitation right in 2 properties, a house in Hâncești that belongs to your son, and an apartment in the town of Chisinau that belongs to your mother. Yes, starting with 2020, I've acquired the right of habitation in the apartment that belongs to my mother in Chisinau municipality. And I continue to have this right of habitation in the house that is in Hâncești municipality that belonged to the father of my son, of my child. And then that was donated to my son in particular circumstances that I can tell you more about. And I continue to this day to have this right of habitation in this property. Please confirm that for 2020 you submitted 2 declarations with ANI, the first one on the 29th of March 2021, where the habitation right for your mother's apartment was not declared, and the second one was a corrected one, submitted on the 9th of April 2021, where the habitation right appeared in relation to that property. Yes. I used that legal tool that allowed me to make amendments to the declaration that was submitted till the 1st of April 2021, because I have I've consulted with the staff of the NIA before I filed the first declaration, after I filed it as well. I talked to them in order to understand, to have more concrete information as to whether I have the obligation to specify this right of habitation in that apartment, although it doesn't belong to me. In fact, I haven't been living permanently there. I was in a position where in certain circumstances related to the health condition of my mother, for a while, Madam Bostan, there are several questions that I'm going to ask, and they also cover the matters that you try now to tell us about. So, to the previous question, you confirm thus that you did correct the declaration. Yes, as provided for by the law, within the limits of the law, and I've talked to the specialists at NIA, who, by the way, said it was not necessary to declare the right of habitation in the conditions that I explained to them. I nevertheless believed, having looked deeper into certain regulations, I've looked into how the provisions of the law covered it. I figured out that I do have the obligation to declare the habitation right related to the property, and I did that within the limits set by the law, in the framework of the law. Starting from your answers to the Commission, please confirm that being asked about why the habitation right was not declared in the declaration submitted on the 29th of March 2021, you explained, you told us that you were not certain you had the obligation to declare that right in the context of the law 133. For what year? We are speaking about the one filed on the 29th of March 2021. So that would be the first declaration that we're talking about. At that time, I was not certain that I had that obligation. The obligation would have emerged if I would have used it as an owner, if I used that property as an owner, because I was living in Hâncești and occasionally I'd come to Chisinau to live there. That's why I said that all the aspects that we want to cover today are covered in the questions that I would be asking. In this context, please inform the Commission in which of the two properties that you declared where you had the habitation right did you actually reside in 2020 and 2021? In both. Now, to have a clearer understanding, in both which ones? So that I can come up with the next questions. In the property in Hâncești and in the property that belongs to my mother in Chisinau municipality. And in fact, to this day, I continue to live my life in just the same way. Hâncești, Chisinau. Now, starting with the facts and the issues that were addressed, and considering the questions that were asked, would you like to add anything? Would you like to explain anything as far as this matter is concerned? Yes. If I may, I would like to provide a bit more details that I hope will shed light on this situation. The fact that I decided to leave, or to rather stay with my mother in Chisinau municipality, that was due to the health condition of my mother. And it was also due to the fact that my mother, after she suffered some trauma in an accident, she lost some of her mobility. So there's me and my brother, but at that time my brother was working abroad, and my mother actually used to live with my brother, but it was only us who were there to provide any support to her. And more than that, considering some personal circumstances, and I mean the fact that the right of habitation that I have is related to a house in Hâncești. That house used to belong to my former partner, the father of my son, and of late we've been having more conflictual situations that led to financial issues, and I was personally concerned in certain, I don't know what to call them, in some litigation related to the debts of my former partner. You can see in Hâncești court that I was also involved in a case in court in relation to the debts that that person had, and I believed I was in quite a vulnerable position if I continued to live in that house. For that reason, at that time, because of the financial issues concerned, and because I did not have enough resources to purchase, and I still to this day do not have the resources to buy a place to live of my own, that's why things have emerged the way they did. I did not have any other possibility. But in order to avoid some issues, personal issues as well, I had to ask my mother to allow me to use her dwelling as a place for me to live in as an owner, as in I took along some personal things. I took some of the things I used to own in Hâncești. And thus I moved in with my mother in that apartment with her permission and the permission of my brother. Madam Bostan, with this algorithm in mind that we detailed previously, I would like to describe some facts to then be able to move to the Q&A. So now, as for the context, according to the information available to the Commission on the 8th of August 2018, your mother purchased an apartment in Chisinau, its value being 973,500 lei. In your declaration to the National Integrity... Sorry, but that is a mistake. 973,500 lei. Sorry if I did not say it right the first time. In your declaration to the National Integrity Authority for 2020-2021, you declared the right of habitation, as we understood, in that apartment. The property is in the central sector of Chisinau and has the square footage of 74 square meters. The building of flats where this apartment is located was put into operation in 2011, according to the authorities in the period of 2007-2018. Your mother did not obtain any taxable income on the territory of Moldova. The Commission asked you about the sources for the procurement of this apartment back in 2018. However, in your answers, in the answers that you sent to the Commission, you have provided an affidavit according to which your mother explained that property was purchased in 2018. After in 2017, she has had an accident which caused locomotor problems. And for her, it became complicated to continue living in the village. So she started looking for an apartment to buy in Chisinau. In your mother's declaration, she informs the Commission that the money for purchasing the apartment were accumulated from 4 sources. Your mother's personal contribution based on the savings she's made throughout her lifetime, especially from working based on an entrepreneur patent at the local market in a village where she lived in. The second source is the selling of an apartment located in Cahul in 2007, one that was inherited from her brother. The contribution of your brother was the third source, who's been working in Italy for about 17 years, and the contribution of your aunt, who's been working in the Russian Federation since 1993. According to your answers that you provided to the Commission, you also explained that your mother was unable to go to the banking institutions to request the release of all the documents as she had locomotor problems, which did not allow her to move outside her house. Also, in your answers, you provided your brother's affidavit, who's claimed that the health condition of your mother has become worse over 2017 and 2018 because of the accident, and that together with you and your mother, you decided to purchase an apartment in Chisinau using the joint financial resources that belonged to him and to your mother. And also your brother has declared that in order to secure the necessary financial resources, he has contracted a loan of 20,000 euros from an Italian bank. Now, there are a few questions. Please confirm that your mother purchased an apartment of 74 square meters in the central sector of Chisinau on the date of 8th of August 2018. Yes, I confirm. Please confirm that this apartment, where you declared your habitation right, belongs to your mother, where she's the owner. Yes, she is the owner of that apartment. Please confirm that in your explanations and answer provided to the Commission, this flat was purchased from 4 sources as follows: your mother's personal contribution based on her savings, and the sale of an apartment, of another apartment, and the contribution of your brother, and the contribution of your aunt. So the 4 sources that were aforementioned. Yes, and also on this note, I would like to take a waiver from the obligation to answer by yes or no. I'd like to just clarify that I did not jointly live with my mother until 2018. I mean, even now, we don't quite have this sort of a joint household. I am aware of these resources from what my mother has told me, because I am part of this family. So I became aware of this decision, of this situation, because my mother told me about it, my brother told me about it, my aunt told me about it, but I never knew what savings my mother had. I never knew what was the financial contribution of my brother or aunt in relation to my mother. I've found out about these details only because I had to find them out to communicate them to the Commission. So I confirm. Besides the aspect that you just told us about, the fact that you know about this information because your mother told you about it, please confirm that when you were asked about this aspect, you've also mentioned the grounds that you did not have this information because they contained personal data that cannot be disclosed to third parties. And also considering your mother's health condition, as she was not able to go to the banking institutions to ask for documentation, supporting documentation that was requested. Certainly, yes. Back then I meant that I was not able to provide those entrepreneurship patents on the basis of which my mother used to work after she retired. And referring to Article 8788 of the Administrative Code, I would like to state that when the person does not own some documents, the relevant body could obtain them through their own action, and I would thus be not subject to the obligation to present them. On this note, I would like to mention that the Commission could have or still can get in touch with the tax authorities in Hâncești to ask for and obtain this information, given that I personally was not able to undertake certain actions for that purpose, because that information doesn't have to do with me personally. Please confirm that in the explanation, in the affidavit of your mother that she's provided, can you confirm that those 4 sources are there, the sources of money used for the procurement of the apartment in 2018? Yes, I am aware of my mother's affidavit, and I saw that she has listed those 4 sources. Once the apartment was purchased, can you tell us when was it that your mother started living in that apartment? I've provided specifications previously in relation to this matter. In discussions with my mother, I've tried to get a proper answer, and I looked back on the situation. And now I can specify with certainty that my mother started living there in November, December of 2018. Because when the contract of sales and purchase was concluded, she's negotiated with the previous owners of the apartment, and it was agreed that they would continue to live in that apartment for another 2 or 3 months, because they needed that time to move all their stuff over to their new place. So as soon as they vacated the apartment, my mother brought along certain things from Hâncești. She's brought the apartment to a condition that one could live in, and it took another month to do so. And at some point in late November, early December, my mother moved to that apartment. I would like to mention that she lives here mostly in the cold season of the year. She has a household in the village of Cărpineni, Hâncești district, and she takes care of it. And considering that that house does not have the right conditions for one to live there comfortably in winter, because she cannot chop wood or heat the stove on her own. In wintertime, she lives mostly in her property in Chisinau. In summer, not always, or rather not permanently, but she occasionally goes to her place in Hâncești. Now, starting from the essence, the substance of the matter that we're addressing, and considering the nature of the questions, Madam Bostan, would you like to provide any further explanations regarding this matter, or was this all?
I would like to mention, especially for the international experts that are part of this commission, that the situation related to the way, if you want to call it that way, that my mother acquired this apartment, and I mean my brother's contribution, I mean the fact that she did not keep her savings in banking accounts, they are all related to a specific trait for our country, meaning that my mother has always been very active. She worked even after she retired. She worked based on a patent, and she had the 2 hectares of farming land. So this was a significantly big household in Carpinian village. She was selling the agricultural produce on the market, and you can get this information from the mayoralty as well. So she never took the risk to put her savings into banking institutions, because she suffered a lot in the 90s when all the money she had on accounts were lost. Therefore, she had no trust towards state financial institutions to hold her savings. That's why her savings, everything that she collected, being aware that old age is quite difficult in our country and she needs savings, also being aware that also thanks to certain aspects, she will provide support to her children and grandchildren. She kept her savings in other ways that were known only by her. Thank you for your answer. Let's move into the same direction. Since you confirmed the 4 sources, I would like us to talk in more detail about each of them. The context. In your answers provided to Commission's questions about the source of funds for purchasing the flat by your mother, you explained that your aunt, living and working in the Russian Federation since 1993, contributed to the purchase of this apartment based on her savings that she gathered between 1993 and 2018. To confirm this statement, you provided copies of the labor records of your aunt for 2 periods, 1993 to 2009 and 2018 to 2020. In your mother's statement about the source of money, she explained that your aunt helped her gather money for this flat by means of international transfers. In this regard, you attached statements confirming bank transfer amounting to 6,300 euros from your aunt to your mother, all of them dating 2016. The attached files confirming these transfers accumulating to the amount of 6,300 euros, and they took place in 2016. In your answers to the Commission, you actually said that there were more confirmation of bank transfers from your aunt, but your mother did not keep them, and they can be obtained by the Commission from banking institutions. In this context, in the following round of questions, being asked if the money transferred to your mother from her sister were meant to purchase the apartment or for another purpose, you explained that the money was transferred to your mother over several years in order to accumulate the needed amount to purchase the apartment. You also mentioned that you know from your mother that her intention to buy an apartment happened in 2015 2016, when she began to look for a more appropriate dwelling. At that point, you submitted an affidavit signed by your aunt, according to which she declared that in 2017, being on holiday in Moldova, she personally donated $3,000 to your mother. Also, your mother declared that over the last 10 years, she contributed with money to support her sister with an amount about $7,000 to $10,000, and that she could not remember the precise amount that she transferred to her sister during the mentioned period. The Commission asked her additionally to explain what was the total amount that your aunt sent to your mother or provided to your mother during the period of 2007 to 2018. Answering to this question, you said you did not actively participate in these matters related to transfer of funds to your mother, not in managing these funds, reason for which you don't have clear and full information about that. Another aspect, on October 12, the Commission asked you to provide confirmation documents on the monthly and annual salary of your aunt in the Russian Federation for the period between 2009 and 2018. In this regard, you answered that you do not have such information, nor did your aunt keep data about the income earned in that period. So you asked your aunt to provide you the information requested by the Commission, and if she obtains certificates about income obtained in that time, she would submit them to you, and at the first opportunity, you would submit them to the Commission. On October 27, 2022, you submitted a request to the Commission to accept it, and the chairperson mentioned that request, and that information is on your table. In the context of this topic, we will additionally look into this as well. Now let's see some clarification questions. Please confirm that your aunt, which is your mother's sister, has been living and working in the Russian Federation since 1993. Yes, I confirm, and moreover, it's not only just Russian Federation. In the extreme northern part, Yamalo-Nenetsk region of the Russian Federation, she also has the citizenship of Moldova. Moreover, she intended to come back to Moldova, and only as a result of some circumstances for limitations in the Russian Federation of her benefiting the right to pension, which means if she comes to Moldova, she will not be able to benefit of a Russian pension, which is significant at the moment. And for this reason, she still keeps living in that region. Please confirm that your aunt contributed to the purchase of the flat that we mentioned, and that belongs to your mother. Both from the explanations from my aunt and from my mother, and also from the bank confirmations of transfers, which were made in my presence, and they were only kept due to the fact that she received them with me by her side, and I was aware that we need to keep these papers. My aunt has been transferring, and she still transfers some help to her sister, which is her only relative. And from discussions with my aunt, she confirmed that her contribution to buying that apartment was about 10,000 euros. Speaking of more precise data or knowledge about that, I have not. Please confirm that you provided copies of a labor record of your aunt for two periods, 1993-2009 and 2018-2020. And the documents that you submitted subsequently we will discuss later on. Yes, I do confirm, because in 2008, my aunt got officially retired, and as far as I know, initially she had a pension of around $600 US. Currently, her pension is around $1,000 US. During that time, 2008 to 2018, my aunt was saying that she was not officially employed, but she was working occasionally, informally. I don't know about the circumstances. Please confirm the intention of your mother to buy this apartment took place in 2015-2016. Based on my mother's declaration, she informed me that at that time she and her sister decided that the sister would come back to Moldova to live again here, and it would be good if she could provide the necessary support to my mother, because my mother is 11 years older than her sister. So it would be good for them to live together and purchase together a dwelling, because the house in Carpineni village is co-owned by my mother and my brother. They live together. So it would be good for her to separate and live as two sisters who always had a very, very good relationship. Based on your aunt's affidavit, according to which she donated $3,000 in person to mother, and the amount of 6,300 euros is confirmed by bank statements. Please explain what was the way of transmitting the rest of the money, the amount of 7,000 up to 10,000 US dollars, as your aunt declared, through bank transfers. And then in 2017, when my mother suffered trauma, my aunt was in Moldova. This happened in her presence, and when she saw the condition in which she left her sister, she informed me. I did not see, I was not part of that situation, but she told me that she left to my mother all her available money at that time by withdrawing it from her account, and it was 3,000, either euros or dollars. I don't remember exactly, as I said. I think in her declaration that is declared more clearly. Maybe I wasn't clear enough. So 6,300 euros. We have confirmation by bank statements. We have the affidavit for the $3,000, and you explained how it happened. Also, in your aunt's affidavit, she says that over several years, she transferred around 7,000 to 10,000 US dollars. So we have a confirmation for 6,300 euros. And that is a lot less than 10,000, and the 3,000 that she left in 2017, that I mentioned. Okay. Actually, I need to intervene here. In her statement, she says that she gave in person 3,000 euros, and through bank transfers, she transferred around 7,000 to 10,000. That's why I am asking, how was that difference transferred to your mother? Also through bank transfers, or when the aunt was coming back, because once a year, once in 2 years, she was coming back to Moldova, and she was leaving her some money. And actually, I realized that that money was also used by my mother for other needs, because obviously the pension that she was having at that moment made her need additional money to solve certain situations. Please explain, what was the total contribution of your aunt to the purchase of the apartment that was mentioned? I can't state that precisely, but from my aunt's declaration, it's around 10,000 euros. But again, I was not part of her family. I was not having a joint household with my mother. Please understand me. We were not discussing certain things like related to her available funds. Now, going back to the materials that were submitted and accepted by Commission yesterday, please explain what information could we find in the documents submitted yesterday, because the Commission had hearings yesterday, and we didn't have time to analyze in detail all that information. Well, I also looked through it, and that information is a bank statement from a card account that reflects both her income, her pension, and her withdrawals from that account. I insisted a lot for my aunt to submit me every document that would confirm her financial funds availability during that period. So she obviously did not keep, or maybe she does not have the ability to get some documents subsequently, but she explained to me that she went to the bank where she has this card account, and that institution, during a time that was longer than the deadline set for me, by the Commission, the bank submitted her information. Some summary, if it's enough. Do you have anything to add to this topic with your aunt? I think no. The next part. According to the answers you provided to the Commission during the round 3 of questions, you explained that your brother, also working in Italy, also contributed to the purchase of this real estate. And in this regard, you submitted an affidavit signed by him. In this case, your brother informed the Commission that his contribution at the stage of the purchase of the apartment was in the amount of 30,000 euros, out of which 20,000 euros as a loan from an Italian bank and 10,000 euros as a financial contribution based on his own savings. Your brother informed the Commission that this contribution was a sum of a loan and his personal savings gathered during the 17 years he worked in Italy, and he sent this money to your mother. Also, your brother explained that he did that partially via international transfers and partially the drivers of buses transporting parcels. So his contribution declaredly was 30,000 euros, and your brother informed the Commission that upon request he could submit the copy of a loan agreement. In the next round of questions, the Commission asked you for a copy of the loan agreement concluded between your brother and the Italian bank. So the contract, the confirmation of payments made by your brother in the context of reimbursing that loan. In the same train of thought, the Commission asked you about the way your brother sent those 30,000 euros to your mother and asked for submission of relevant documentation in this respect. Additionally, you were asked to explain the source of those 10,000 euros declared as own savings of your brother. Bostan, sorry. In your answers to the Commission, you declared that your brother only provided a copy of the abstract issued by the Italian bank showing the amount of loan, the date of contracting it, and the date of and the due date. Also explained that the copy was not of a loan agreement was not submitted to you because your brother, being a truck driver, he could not have access to those documents. So, based on information provided by you and documents attached from your brother, the Commission found that at the date of taking that 20,000 euros loan by your brother, so this happened on April 4, 2019. The Commission asked you to explain the date of when this 20,000 euros loan was contracted by your brother and to provide the relevant documentation. When answering this question, you informed the Commission that the 20,000 euros loan was contracted on April 4, 2019, as mentioned in the information received from Banca Italiana, from the Italian Bank. The copy of the loan agreement was not kept, and the certificate issued by the bank was only provided to the Commission. According to your brother's explanation, the 20,000 euros loan was contracted for repair works and furbishing the apartment. In this context, you submitted a notarially authenticated statement of your brother, which is explaining that at the stage of purchase of apartment, he contributed with 30,000 euros with his own savings, and in April 2019, he contracted a 20,000 euros loan when contributed for repairs and purchasing furniture for the flat. Please confirm that your brother has been working in Italy for around 17 years. Yes, I confirm. Moreover, I would like to add that he is currently back in Moldova my insistence, also because I wanted to talk to him personally and with the mother to clarify these details. So he's in the country and he could make statements. He went to the notary. He accepted to make those declarations. My brother, before leaving the country, he was having a joint household with my mother. So they were living in the same household. And now, if he does not go back to Italy, he will stay and keep having joint household with my mother. Please confirm that your brother contributed to the purchase of a flat that was mentioned. Yes, he did. I knew that even before the apartment was purchased. And I asked for clarifications later on because these discussions I had personally with my brother. Madam Bostan, what was the total contribution offered by your brother for the purchase at the time when this apartment was purchased? Well, based on the discussion that I had with my brother after he came back, he explained, or he clarified, also in front of a notary, that his contribution for buying the apartment was around 30,000 euros. And later on, in order to improve the condition of that real estate and to adapt it to decent living conditions for my mother, he used that loan that he contracted in 2019. In the summer of 2019, he came back to the country, or maybe even spring, I don't remember precisely, and I cannot be concrete here. He carried out personally repair works with another person, and he used the funds that he acquired as that loan, and also probably from what he also gathered. To summarize, could you please tell us exactly what was the amount that your brother spent at the time of purchasing and at the time of repairing the apartment? This is the amount declared by my brother in the notary declaration. 30,000 for the purchase and around 20,000. He did not keep records exactly how much he spent for the improvement of the apartment. How do you explain the discrepancy between the two affidavits submitted to the Commission by your brother? In the first one, he said that it was a 20,000 euros loan and 10,000 as personal savings. And the second affidavit states that he contributed with 30,000 euros during the purchase and 20,000 as a loan to repair the purchased apartment and furniture. This is what my brother declared. He's been living for 17 years in Italy. Maybe there are issues in expressing himself, clarifying things, and he does not have a very high level of education and skills. Actually, when I asked him to clarify, he was at work, he was on the drive, he didn't even have a sheet of paper to write down his declaration. So probably the lack of clarity was because of the hurry and conditions under which this was made. I did not tell him what to write. He just did it on the hurry because I also had to hurry up to fit the deadline. Later on, I decided that we need to be more precise and had as much clarity as possible, and he accepted to do that by coming back to the country and making this declaration. I would like to mention again that my brother, in the last 5 years, he didn't even rent an apartment in Italy. He was almost living at that station where he works in order to gather money, to make savings, in order to have funds available so that when he comes back to the country later, he would have to decide how they will live with the mother when having a joint household. Based on the fact that it was mentioned that this apartment, or that certain amounts were spent to repair this apartment, could you please tell us what was the condition of that apartment? Well, it was an apartment where a family of 2 children lived for 8 or 9 years, if I'm not mistaken, based on their explanation. I cannot say it was in a disastrous condition, but obviously he needed some interventions. Saying some, I remember when I was at some windows at the balcony that were missing, and it was called the flooring of the apartment was already in a condition that needed replacing. I cannot say that it was an apartment that was not livable. It was, but not in conditions that would allow for a decent living. But it needed interventions. So it needed repairs, interventions. Of course, first of all, what it needed first and foremost, it was furniture. It needed to be adapted to living. When my mother moved in the winter of 2018, she brought things from her dwellings, like the minimum things that she... When did the works started and how long? Repairs started in spring or summer of 2019, and it lasted until autumn, like 2 or 3 months, because it wasn't capital repair work, just some interventions to adapt it, to make it decent for living. And I remember now that I was with my brother buying this flooring, wallpaper, paint. I mean, I joined him visiting these shops in order to get... So, who paid for the repairs? Of course, my brother. But who carried out the works? He did personally, together with one more person. He's sort of an acquaintance of ours. He clarified things with him, like speaking of remuneration for this support provided. But my brother worked in Italy in constructions as well, so he has skills, he can perform works. But he paid to this worker. I cannot tell you precisely. Probably he paid some, but I don't want to raise this issue because I did not clarify it. That person is in the country. I can identify that person and I can clarify. You did not ask me about that. That's why I did not establish it. Well, since you said furniture was purchased as well, could you please explain how much money was spent to this end? Together with my brother, personally, we went, and I was present when he purchased it because, of course, he needed to consult a person who has some knowledge. So he purchased a refrigerator, a washing machine, a TV set, and kitchen furniture, and a stove, with my participation. And for the rest, I did not take part in it, and I cannot say. I would like us to address another topic regarding another source that was used to purchase this apartment, and I mean your mother's personal contribution and context. According to the answers provided to the Commission, you explained that your mother also contributed to the purchase of this apartment based on her own savings. According to your answers and the annexes that you submitted to the Commission, your mother declared that the apartment was purchased personally by her in 2018 for 973,500 lei. In her statement provided to the Commission, your mother explained that part of the money was obtained from selling the apartment she inherited in 2007. Also, your mother stated that the purchase was based on her own funds and for contribution of her son. Your mother declared that she collected or saved the money for the mentioned apartment by working after retirement as an entrepreneur at the market in the village she was living, and she was selling various things. Until 2010 to 2013, she was not remembering precisely. The Commission asks you to explain what was your mother's contribution to purchasing this apartment. Also, the Commission asked you to explain what goods was your mother selling on that village market and how much funds, how much money she was gathering annually from this. Also, you were asked to provide confirmation documents, including entrepreneurial patents. In your answer to this question, you explained that you personally do not have information that would certify precisely what was your mother's personal contribution for the purchase of this apartment, because she used her life savings and also the money that her sister was working in the Russian Federation and her son sent to her. So you informed the Commission that you cannot provide authentic information regarding the amount that was personally invested by your mother to purchase this apartment. Also, you explained that your mother was selling household goods, some clothing, as well as agri-food products from her farm, because she owned agricultural land plot of 2 hectares and a garden of half a hectare with vineyard and orchard. So you were not aware of the annual money she made from this activity, because this was her work and you never got involved in managing the funds given by your mother. And now questions. Please confirm that your mother was working at the local market in her village, selling household goods, clothing items, as well as agri-food products from her farm. I confirm, and this was done based on a patent. And according to the legislation in force, the patent holder was not obliged to keep records or provide tax returns. And based on this situation, the mother, well, asked by me to provide details, said that everything that I gathered was a result of my work, as a result of some selling some agri-food and funds that my sister sent. What was the amount of 20,000 euros? When, in what year, how much she gave it? Obviously, I don't know. We will go back to this, but you confirmed that she was working on the market, and you informed us that she was working exactly based on a patent.
The request that we filed, no documentation was provided to support this or to reflect, to show the entrepreneurial period. Yes, well, she did not keep that. What is more, she did not need it because she was a retiree already, and there was no need to keep that in order to potentially use at some point in the future to confirm some period of work. A source of revenue claimed was the sale of an apartment in Cahul. Madam Bostan, can you tell us what was the revenue earned out of the sale of that apartment? Well, excuse me, but you did not provide me this question in writing, and I did not acquire documentation in this regard. But this has happened either in 2007 or 2008. I don't know. That was in 2007. I don't know. If I would have been asked about it, I would have looked into it. At this moment in time, can you tell us, can you estimate what was the total contribution of your mother? You sort of did identify something previously, but do you confirm it? Yes, on the basis of what my mother said. She declared, she said in quite precise terms that everything that she's invested, the 20,000 euros invested in the procurement of the apartment, was based on those money that she's accumulated and saved from selling the apartment, and accumulated from the work she's performed, and also from the financial support of her sister. So that's where the 20,000 euros came from and formed her contribution. But can you make a difference between these revenues at this moment in time? For instance, if I asked you whether you knew more or less, or if you have a more precise amount about the revenues registered on the basis of her patent activity, but she did not have the obligation to register it. But I mean, do you know about any revenue she's made? Oh, you mean what she's earned? Well, I don't know for certain, and she doesn't know either. She is an older person, and all this has happened 10 years ago. Well, obviously, she couldn't provide me a proper records and accounting, but if I made some estimates, then I would be at risk of not being precise enough. Now, starting from the matter discussed and the nature of the questions that you answered, do you have anything else to add? I think not. Thank you. Let's move on to another matter, Madam Bostan. According to the information available to the Commission, over 2012-2015, you held 9 bank accounts opened in your name. 6 bank accounts were opened before 2012, 1 bank account opened in 2012, 1 bank account opened in 2013, and 1 bank account opened in 2015. Between 2012 and 2015, the law required the subjects of declarations to declare all bank accounts, which means that for the year 2012, you were supposed to declare 5 bank accounts. For 2013 to 2014, 6 bank accounts had to be declared, and for 2015, 7 bank accounts had to be declared. In your 2012 declarations, no bank account was declared. In the declarations for 2013-2014, you declared only 1 bank account as a salary bank account. In your declaration for 2015, you declared 3 bank accounts, including the bank account opened in 2015. Well, actually, the information on these accounts was presented to you at the Q&A rounds. In your answers to the Commission, you explained that some of these accounts were opened by your employers as salary bank accounts, and that a part of them were credit accounts and a part of them were not active at the moment when the declarations were submitted. Please confirm that in the period of 2012 to 2015, you held 9 bank accounts. Yes. And this is something that I looked thoroughly into when the honored Commission let me know about it. Please confirm that for the period 2013-2014, you declared 1 of the 9 bank accounts. Yes. Please confirm that in your declaration for 2015, you declared 3 of the 9 bank accounts. Yes. Please explain why you did not declare in your annual declarations for 2012-2015 all the bank accounts you held at the moment in time when you submitted the declarations. I didn't do it because I thought that the obligation to declare bank accounts, according to the law, such an obligation emerged only where those bank accounts had ownership rights over them, as in if I had funds on those accounts. So there's the provisions in Article 4 of the law that says that I must declare bank accounts that are related to ownership rights of the declarer. But considering that there was no money on the accounts, there was 0 funds on those accounts. For that reason, I did not declare them. And I think that this comes out from the provision that I just referred to. An account is not my ownership. It's a tool, a means used by the bank. I cannot include it as my own property, and my property would have only been the funds. That would have been my property, the funds on those accounts. And considering that there was a null amount of money on these accounts, and I provided the turnover, the account activity, I thought there was no obligation associated with it, and I did not have to declare it. What is more, this situation is very typical of most of the civil servants, because there was no clarity. We were not properly explained, we were not properly detailed what this obligation entails. And as I understood and as I communicated to the Commission, but reading the law, it doesn't clearly come out that accounts with null funds on them, with 0 funds on them, were supposed to be declared as owned by me. Considering the complexity of this matter, though, would you like to provide any additional explanations? I would like to explain that some of these accounts were accounts that were opened by my employers when I worked in the enforcement office in 2003 in Chisinau Court, in Hriptievschi Court. Since I knew that I no longer used those bank cards, I knew I had no funds there. So I deduced from the provision that I referred to that I did not have the obligation to declare them. And the National Integrity Authority never brought this issue up. They were checking our declarations. They never asked about it. And I was even surprised to find that the accounts haven't been closed. They are not supposed to be closed at my request. It's up to the bank institution. There's one thing I'd like to have more clarity about. So you are speaking about accounts on which there was no account activity. Actually, considering the policy of personal data protection, I will nevertheless try to ask you a question. And given that this question was asked previously, I hope you understand what account I'm talking about. So there is a Mayib bank account from 2006 in lei, 100,000 lei credit on it. In 2015, starting with 2015, do you mean? It was opened in 2016. Yes, it's for a credit. It's a credit bank account from Bank, but it was not declared as a bank account. But it's credit reflected, so obviously it's related to an account. I did not have any clarity about that fact that I had to declare it as an account. I reported it as a financial liability to the bank institution. That's how I perceived it, not as an account, but as a liability. I would like to thank you for the answers that you provided, Madam Bostan. Esteemed Chairperson, I have no further questions with regards to this matter. Thank you, too.
Thank you very much. And I'll give the floor to Victoria Henley for follow-up questions.
Good morning, Ms. Bostan. I have some questions that relate to the meeting of the Assembly of Judges on September 27, 2019. Just for context, on September 20, 2019, as president of the administrative panel of the Chisinau Court of Appeal, together with other judges, you examined the case regarding the obligation of the Superior Council of Magistracy to convene the General Assembly of Judges. In its decision of September 24, 2019, under your presidency, the panel decided to convene the General Assembly of Judges on September 27, 2019, with the establishment of an agenda for the meeting, one of the subjects being lifting the mandates of the then serving permanent and alternate members of the Superior Council of Magistracy, elected by the General Assembly of Judges. On September 27, 2019, you participated in the General Assembly of Judges that was convened on the basis of the decision mentioned earlier. At the opening of the Assembly, you publicly announced the decision adopted on September 20, 2019, and read the operative part of the decision to the Assembly. You also expressed your personal position about the state of affairs in the judiciary and the need to change it. Please confirm that you were the president of the administrative panel of the Chisinau Court of Appeal that on September 20, 2019, examined the case regarding the obligation of the Superior Council of Magistracy to convene the General Assembly of Judges.
I certainly confirm. That is a certain fact.
Please confirm that in its decision of September 24, 2019, under your presidency, the panel decided to convene the General Assembly of Judges on September 27, 2019.
I confirm, but I also believe that I need to add certain details. It is not the panel that decided it. It decided to allow for that action that was formulated and to demand the Superior Council of Magistracy to convoke the General Assembly.
Please confirm that the decision established a draft agenda for the meeting, one of the subjects being lifting the mandates of the then serving permanent and alternate members of the Superior Council of Magistracy elected by the General Assembly of Judges.
I admit that there is an action allowed according to Article 206, corroborated by Article 224 of the Administrative Code. It demands of the court, when it allows, when it accepts an action, it entails the obligation to issue an individual administrative act with the contents requested in the procedure before that and in the civil action initiated by the claimants. And that what the panel of the judges did. It allowed for that action. It accepted it.
Please confirm that on September 27, 2019, you participated in the General Assembly of Judges that was convened on the basis of the decision mentioned earlier. And at the opening of the assembly, you stood in place of the president of the SCM, who was not present, and announced the decision adopted on September 20th, 2019, as well as your role in it, and then read the operative part of the decision to the assembly.
I certainly confirm, by having participated in that assembly, I discharged my professional duty in Article 230 prime of the law, and the General Assembly being a self-governing body of the judicial system, I believed, and I still believe, that I had the right to also share my personal opinion with regards to a certain situation that had to do with the professional administration related to the fact that I have thus opened that assembly. And that was due to the circumstances because the SCM has ignored the invitation to show up in that assembly. And according to the regulation, the assembly is to be opened by the president of the Superior Council of Magistracy, who, as I mentioned, did not show up at the assembly. And in order to secure the solemnity of that forum of judges, I was asked by my colleagues, and I decided as the president of the panel that accepted that action, and thanks to which that assembly took place, I accepted to hold the opening remarks of the assembly. As regards my opinion that I shared, it is my position that I had and I still have the right to share my opinion as a judge, to share my opinion, albeit a critical one, with regards to situations happening in the judicial system.
Please confirm that at the assembly, you also announced that the decision of the Chisinau Court of Appeal was final and enforceable, and you also read the resolution of September 24, 2019, by which the Administrative Court Panel of the Collegium of Civil, Commercial, and Administrative Proceedings, consisting of you, Judge Palanchuk, and Judge Mali, had ordered the adoption of the Administrative Act in order to enforce the decision of the Chisinau Court of Appeal of September 20, 2019.
To confirm what exactly, sorry? Could you read that out again, because I lost the thread?
That you announced that the decision that had been reached by the Chisinau Court of Appeal was final and enforceable, and you also read the resolution by which the Administrative Court Panel had ordered the adoption of the Administrative Act in order to enforce the decision of the Chisinau Court of Appeal on September 20, 2019.
So in this regard, you mean the ruling that the panel has issued as an enforcement body for that decision, for that court decision. That is also in line with the administrative code, considering that the Court of Appeal is a body that has the powers to enforce court decisions pronounced in administrative court. And what you referred to was a ruling whereby, in line with Article 253 of the Administrative Code, the panel has initiated issuing an individual administrative act, which was the subject of the final decision, in a circumstance, in a situation where the Superior Council of Magistracy, the defendant, has refused to enforce, to execute that decision, that judgment. I would like to mention that I did not state my own position at that time. All I did was read out loud the judicial acts that were pronounced, that were res judicata and have gone through the legality control of the hierarchically higher judicial body.
And I believe that we have furnished you with a copy of the transcript of your remarks on that day, if you'd like to refer to it. But please also confirm that you also announced that the decision was final and enforceable.
Yes.
And please also
Yes, I read out loud that, sorry for interrupting you, I read out that operative part, the disposition. I read out loud the dispositions from the Judicial Act. That was not my disposition or me pronouncing it. It was reading out loud the final decisions, final dispositions that had already gone through the control of legality.
Correct, but in addition to the actual resolution and the decisions themselves, you also stated that the decision is enforceable and may be appealed in the Supreme Court of Justice. However, by yesterday's decision to the SCM, it became final. Can you confirm that you made those remarks?
Perhaps if I said that, I did that in good knowledge at that time, I guess.
Please also confirm that you announced the number of persons who were in attendance at the General Assembly and declared that there was a quorum and therefore a deliberative and valid extraordinary assembly of judges.
Well, if you say that you've heard those recordings, now I can't remember word for word what I might have said, but I do not doubt that and I do not question that you are right. But I would like to make a comment in this regard. When it comes to the decision, I believe that this situation cannot no longer be commented by me, or I can no longer make any additions to that. On the basis of the law in force and on the basis of the Code of Ethics, that was a collegial decision. That, I repeat, is res judicata, a matter settled. But as regards the questions around my personal opinion that I shared at the General Assembly, I would like to mention yet another time that the right to opinion, I have the right to opinion as provided for in the Constitution and as provided for in the law. And I do not believe that I had to provide further details with regards to my own opinion regarding certain situations that were occurring at that time in the judicial system, and that, by the way, have been put forth and highlighted in a declaration from the Parliament when they talked about a captured state. So those were my own opinions that I gave voice to by capitalizing on my right to have an opinion. I hope this doesn't upset you, but when you're asking me to comment on my own opinions, I might be under the impression that these questions have a discriminatory note to them compared to those colleagues who have been heard previously and who did not participate, as in they did not take the floor at the assembly, they did not say what their opinion was, and you did not ask any such questions of them.
Just to be clear, I'm not asking you about your opinions. I'm asking you just about your conduct during the Assembly of Judges on that day. And could you please also confirm that you, after the statements made about the quorum, proposed to proceed with the agenda without delay and announced that it was required to elect a chairperson and secretary for the forum, and that you then nominated Alexandru Gorgish as president of the General Assembly of Judges and asked that his candidacy be voted on and that the vote be counted?
I do not want to comment what followed and what happened at the Assembly. I repeat, that was a body that, according to Article 23, is a judicial self-governing body, And it really upsets me that you are displaying situations, or putting me in a situation where I have to argue that conduct. What were the objections? What are the objections to my behavior, to my conduct in the General Assembly? Did I show any lack of respect for ethics, for fairness? That was the conduct of a judge participating in the forum of a deliberative body, professional deliberative body that the judge was part of.
Having participated in the panel that ordered that the Assembly should be convened on September 27, 2019, do you believe that any of your actions while you were at the General Assembly session might have given rise to any doubt about your impartiality, objectivity, or integrity, or prejudiced in any way public trust in the judicial system?
When, alongside my colleagues, we issued that decision, esteemed Madam, I had no knowledge of what would follow. We pronounced that on the basis of the law, by strictly following the personal perception of the meaning of law, guided also by the knowledge that I had the responsibility to apply the law correctly, also guided by the knowledge that I had to be impartial when that decision was issued. Everything that happened afterwards it was all about securing my right to sharing my opinion and expressing my position in my professional capacity as a judge. And the General Assembly was the supreme self-governing forum. I do not believe that by issuing that decision, I was deprived by the right to express my opinion on the condition of things as they were happening in the system at that time. I had a critical opinion, by the way. And for that, I had been persecuted professionally for it. I do not want to tell too much about it in this regard. But yet another time, I would like to mention that I am affected by the way in which you are formulating these questions. And I think that as long as these questions were not put to other colleagues who have participated in the hearings, this makes me feel like I am discriminated against.
Is there anything else you'd like to add or clarify with respect to this issue?
Only to reiterate that at the General Assembly I expressed my position as a judge that was knowledgeable of how things were inside, and as a judge that knew things were not going the right way and that things needed to change by joint action of all the judges. And I expressed my position to support a reform strategy, an objective and fair reform strategy, a position that I actually am faithful to this day. As regards the decision that was issued, it has the power of a settled matter of res judicata, and nobody can question that decision. If this decision had a different meaning attributed to it, then I am certain that Moldova would have been convicted at the European Court for Human Rights, because another legal solution for the action that has been settled couldn't have applied.
I have no further questions.
I am looking at my other colleagues whether any follow-up questions. That doesn't seem to be. I have one question myself, and going back to the discussions about the purchase of the apartment for your mother in Chisinau and her financial contribution to that. You mentioned that in 2007 or maybe 2008 she sold the apartment in Cahul. And at the same time, we have information, according to the tax authorities, that between 2007 and 2022, no income was registered at all. So my question was, if she did sell the apartment in that time frame. Did she declare that with the tax authorities? Was there any taxes paid over the capital increase over the apartment? Is there any clarification that you can provide on that one?
I cannot provide any details regarding it. I know that there was an agreement authenticated by a notary, and obviously the notary is to submit such reports to the tax authorities. So I do not even know, I don't know if my mother had the obligation to pay this contribution that we referred to, because this apartment came into her ownership because she's inherited it as a successor. So she's inherited that apartment when her brother, passed away. Her sister gave up the succession rights. That is, my aunt gave up what she should have inherited because there were 3 children. So my aunt gave up her rights to that apartment, and my mother became the only successor to that apartment, and my mother decided to sell that apartment without me being involved with this process in any way whatsoever.
Thank you. Well, I think that brings us nearly to the end of our proceedings and hearings this morning. I would like now to give you the opportunity, as I mentioned in my introduction, to make a brief closing comment at the end of the hearing, and then after that we will close the hearing. So you have an opportunity, if you would like to make use of that, to make a brief closing comment. Please go ahead.
I certainly would like to use this opportunity. I would like to thank the honored Commission for the questions asked and for the openness. I also tried to be as open as possible. I would like only to mention a couple of details. Not me, not other colleagues who are subject to this evaluation. We were not aware about the way where this procedure would look at. And as we didn't know that there would be this legal framework with some obligations that we would have to discharge, I personally might not have lived up to the commitment of being very concise, specific, precise in relation to everything that has to do with financial, tax matters and all the documents and all the situations that we've looked into. When there were legislative amendments, obviously each and every one of us will make sure that due attention is given to such situations. I might not have been a paragon of discipline, of financial discipline. However, when it comes to my openness to declare all my revenue, to provide details on every situation I was concerned in, and as a declarer, I tried to always be as precise, fair, open as I could be, and I always try to observe the law. As regards the situation that brought me in front of you, I decided in good knowledge to do this, to perform these verifications in pursuit of making it to the Superior Council of Magistracy, because in 16 years of work since I started as a clerk, interpreter, having gone through all of the stages in the judicial system, I know where the gaps are in the system. And it is my hope that I know, or that I can contribute to finding the solutions that would ensure the improvements necessary in the system, and that together with the government authorities that also pursue some reforms and certain actions that are perhaps not always completely understood or perceived by the system, I think that then we might be able to establish the rule of law and an independent judicial system that has integrity. Thank you, and apologies if at times I might have been not clear enough.
Thank you very much for your comments, closing comments. We have hereby come to the end of the hearing. I thank you for all your comments and answering all the many questions that we had to you. The Commission will now withdraw for deliberations and the decision will be delivered later. As much as possible, the Commission will strive at delivering the decision within a month as of the date of this hearing. I thank you very much again, and I hereby declare the hearing closed. Thank you.
Thank you.